The Cyprus Association of Translators and Interpreters, CATI, was the first association established in Cyprus in August 1989. It was just before, 10 years before the Pan-Cyprian Union of Graduate Translators and Interpreters. In June 1990, the Council of Ministers of the Cypriot government decided on the Press and Information Office, PIO, under the Ministry of Interior, providing certified translation services. Two parallel paths without involving necessarily the concept of collaboration. Rivalry was born instead between the government's official translation sector and the CATI at that moment. In February 1996, the CATI joined the International Federation of Translators. Upon the 50th World Congress in Melbourne, ratifying the relevant council's decision of the Federation. In 1998, the Council of Ministers amended its decision on the PIO's providing certified translation services by fixing, for the first time, selection criteria for the translators' recruitment. In September 1999, the then Council of the CATI signed the last minutes ratifying the dissolution of the association to set up a new one, more efficient, more reliable, and more professional. In October 1999, the Pan-Cyprian Union of Graduate Translators and Interpreters was set up during the inaugural meeting attended by the 2/3 of the CATI's former members. The second object out of the 5, as defined in the Pan-UTI's constitution, focuses on advancing recognition of translators and or interpreters as qualified professionals by the state and upholding their professional rights. Later, 4 actions have been undertaken by the Pan-UTI's Council in 2000, then in 2007, later in 2010, and last year, aiming at rectifying the error committed by the CATI's first council. It was our error. So, we are going back to the Constituent Assembly of the Cyprus Association of Translators and Interpreters. It was held on the 20th of November 1988 in Nicosia. The problem with the members of the association councils was that they lacked experience in trade unionism and failed to coordinate their efforts to this end, which ended to the then spokesman of the government in 1990 being the political head of the Press and Information Office, PIO, under the Ministry of Interior, submitting a proposal before the Council of Ministers. According to this proposal, the Council of Ministers was requested to appoint the Press and Information Office as the competent authority for providing official translation services. Why the PIO? Because the PIO has always been the government's department staffed by language-speaking people, yet not necessarily translators, because in the government, so far, there is no official scheme for the recruitment of civil servants defining services to be provided by them in terms of translation. They are all of them civil servants. They are not recruited for translation services. So, the PIO's job was to write press releases and inform the citizens on the world news. This is the first mission, officially. The second mission of the PAO has always been to inform the world about Cyprus in general. Further to the above activities, the Press and Information Office provides technical audiovisual assistance to journalists. It is cooperating very closely with the journalist world. The PAO's people have therefore strong connections with both the media and the political community. The Cabinet's decision by which the PAO was appointed competent authority was enforced in June 1990. There has been conflict of interests since the beginning of the PAO's translation sector becoming operational. Where there was nothing legally blameworthy in the wording of the Council of Ministers' decision, the way the permanent staff, the civil servants of the office, practiced the newly assigned tasks was far from reminding fair governance. But it wasn't written, it was verbal, so no evidence. In theory, the freelance translators, in theory, were very carefully selected based on their qualification complying with high standards. According to the PAO's translation sector staff, they have always been acting in accordance with the laws and the regulations without prejudice or discrimination against whoever, and they do their best to provide promptly services to the citizens. This is what is written officially. In real terms, a more practical approach is made, which no evidence is available for. The only action taken by the CATI was in 1992, and we applied to the Ombudsman for an opinion as advised by the association's legal advisors. The Ombudsman opinion was in favour of the CATI's request, yet it played an advisory part, and his opinion was neither enforceable nor binding. Later, after the Pan-Cyprian Union of Graduate Translators and Interpreters was set up, in 2000, we assigned to another law firm to act on behalf of us, and the PAO was for the first time forced to enlarge their so-called list of freelance associate translators, including some members of the Pan-UTI, but it was not what we wanted them to do. In 2007, the Pan-UTI filed a complaint before the Commission for the Protection of Competition. A pretended investigation lasting 2 years was then launched. According to them, 2 definitions were put forward. The Pan-Cyprian Union of Graduate Translators and Interpreters was the claimant. The claimant was then defined as a professional and non-profit-making association based in Nicosia, aiming, amongst others, at the state recognizing by any means the translators and interpreters as qualified specialists and securing their professional rights. On the other hand, the translation sector of the Press and Information Office was the respondent. The PAO was then defined as a Ministry of Interior department which was entrusted with the competency to interpret and implement the government's policy by publicizing and diffusing information, keeping, therefore, the mass media informed, full stop. The PAO's translation sector was established by virtue of the decision number 33.581, taken by the Council of Ministers on the 4th of June 1990, to meet the translation needs of both the private private and public sector. Though the PIO forces us to act as its subcontractors in order to collect the translation fees on its behalf by using the certification as an excuse to control the translation market. The Commission concluded 24th September 2009 that the PIO holds a dominant position on the market, but it rejected our complaint about the PIO abusing its dominant position. Behind the doors, the civil servant in charge said to our lawyer, you know, Mr. X, it's a government's department. There is a decision made by the Council of Ministers. We can do nothing. Behind the doors. So the matter raised then by our lawyer was to define precisely what the term certified translation stands for. In essence, certified translation signifies that the translation is simply produced by a translator who certifies its accuracy, and the translator's signature is subsequently legalized by a PIO's civil servant. This is how the translation becomes what the PIO calls certified. According to the official seal provided, it reads, I hereby certify that this text is a true translation of the attached document. No source, no target, nothing. Then the translator signs, and underneath it reads, I hereby certify that the signature of the translator is that of, and the name is written. And who signs that? For the Director of the Press and Information Office, Republic of Cyprus. Normally, well, to tell the truth, this is not legally valid. It happened in the past in 2 cases before the Supreme Court that 2 judges rejected the documents provided because they considered these void. No law exists to ratify what the decision of the Cabinet says. It's an executive power. On the other hand, it is the parliamentary power, and there is no law. The freelance translators may either maintain their autonomy and be rejected from the market of certified translations due to lower fees by the PIO, or accept to act as the PIO subcontractor, entering therefore into a subcontracting verbal agreement. No written agreement is signed. Furthermore, it is up to the PIO to decide at its discretion whether it needs such associate or not. Besides, according to allegations by the PIO, all translations produced by freelance translators, our members inclusive, should be forwarded to its translation sector for editing, as it is the competent authority pursuant the Cabinet's decision. Thus, freelance translators are automatically placed out of the market due to the editing fees claimed by the PIO, as above stated. The client is requested to put in the envelope the documents from all over Cyprus and the money to send them either by taxi or go in person to deliver them, and then the documents, once translated, they are sent back to the client. This is how the system works. If our members who happen to be associate translations of the PAO wish to cooperate and be responsive, they should put the documents in the envelope, not get any payment by the client, and send the envelope to the PAO. They can translate, no problem, but they will be paid by the PAO, deducting the commission. The fees normally are fixed at 25 euros per page or per 250 words. They have just taken our way of pricing. And the associate translator gets 16. So the difference is the commission of the PAO. It's an agency. But they are backed by the cabinet's decision. So later, all the decisions made by the Commission for the Protection of Competition during the mandate of its then president were declared void by the Supreme Court following 4 oil product companies appeal against the Commission. The problem was that the appointment of the Commission's president was considered an infringement of the relevant law pursuant to the Supreme Court's judgment, meaning that the president appointed by the former government didn't have the qualifications to be the president of the Commission for the competition, for the protection of competition. So the decision made by the Commission regarding our case is void. In 2010, and thanks Fit for that, and I have to thank in public Andrew Evans because he assisted enormously our association. He was the one to advise us how to act. And he gave me the name of the head of the antitrust unit of the DG Commission of the European Commission, and we lodged a complaint about the violation of our rights to work as professional translators. And, well, I feel the need to thank him sincerely because it was a success. But the former government didn't want to admit it publicly. 2 years passed in 100% silence, and all the members of the then Council of the Pan-UTI thought we failed, but we didn't. They drafted a tool. We didn't know of that. It was a bill of law to be voted by the Parliament on sworn translators. But it was a lethal injection to eliminate totally the Pan-European Union. It's a matter of political decisions. The first retaliation measure against Pan-UTI was taken in June 2009 upon the Commission for the Protection of Competition deciding on no evidence and decided to close our case, the investigation. So, what was a retaliation measure? The instructions given to all the government services and departments to accept translations, but done by the PAO. No way to accept an affidavit, not even the court. So we were totally excluded. It was a retaliation measure. And I remember what Andrew Evans asked me to do. He advised to forward the letter of lodging the complaint before the European Commission to the members of the European Parliament, both Cypriots and Greeks. I didn't, because I knew that there would be a retaliation measure. Yet, I did it informally to one member of the European Parliament, who is currently the Minister of Foreign Affairs of Cyprus, Mr. Yanakis Kassoulidis. So he knew. And after the new government took office, in June 2013, last year, we addressed a letter to the head of the department dealing with state versus citizens cases at the ombudsman's. And relevant documents were attached. And we forwarded all the documents, the set of them, to both the Minister of Foreign Affairs and the current Minister of Justice, because we wanted to get the Council of Ministers involved without violating the protocol. And we asked them to get involved on a political level and on an administration level, and they did. So I'm delighted to inform you that this malicious intent tool about the sworn translators law was rejected in last November by the decision makers, and this has been the outcome of public consultation. When they found out, they decided to insert the document in the website of the Ministry of Interior and ask public consultation. We provided our comments, 14 points, and hopefully this document is rejected. Some decisions are taken. We are not aware of these decisions, but we understood, we felt it, that something has changed. We are desperately waiting for the Cypriot government in office implementing the reform of the public service. The new law about the reform of the public service will hopefully be enforced on the 1st of coming January. Modernizing the public service is entirely a target to achieve by the current Cypriot president, who talked about the need to transform the public sector into a more flexible and truly efficient one during his presidential election campaign. That is the story. We hope that this will be eventually concluded. We cannot say or give more detail because we don't know what they have decided, and we are not allowed to anticipate their decisions or their official announcement. But we hope that this will be positive at last for us. Thank you.